righty. I have 11 a.m. on the dot, and I am very prompt, if nothing else. So let's get started. Welcome to our Visiting Angels Coffee Chat. My name is Mary Ellen Wilson, and I am your Business Development Manager here at Visiting Angels. If this is your first coffee chat, it looked like we had a lot of newbies this week, so welcome. We're so happy to have you here. As you may know, Visiting Angels provides senior home care for older adults who prefer to age gracefully in place in their home and community. We have 4 offices. We have an office in Gaithersburg, Silver Spring, Washington, D.C., and Edgewater, Maryland. So many offices to serve you and your loved ones. Now, as part of our community outreach, we implemented these coffee chats, gosh, over a year ago. It's been, I guess, a year and a half now. It was when COVID hit. We were no longer allowed to go out into the community and meet with you in person. So we thought, well, let's pivot. Let's start doing some coffee chats virtually. And that's what these are. These are bi-monthly, every other week coffee chats where you can come on. We invite a guest that will share with us a topic of interest to our older adults community. We'll give you a chance for Q&A at the end, and it's a lot of fun. All right, so let's get started. It's been a minute since our last coffee chat. We were kind of on hiatus in May, but one of our last topics was estate planning, and we had a wonderful estate attorney, elder law attorney, Andrea Bador, who told us a lot of the ins and outs about what types of documents you need in place. Well, today I'm really excited to bring part 2 with Lindsay Michaud. She taught me how to say her last name because it's not spelled that way. Lindsay Michaud from Capital One. She is in private banking. She's a relationship manager, and she deals with over $250 million in deposit assets. But what is near and dear to her heart is making sure that people understand that what those documents mean, but also when it's appropriate to use what, and what does that signing mean for this. And so we're going to take it the next step. So our attorney gave us a broad overview. Lindsay is going to dive in and share with us some items that we need to be aware of, the nitty gritty. All right, so Lindsay, welcome, welcome, welcome. I'm going to just let you take it away.
Let me roll, huh? Well, again, thank you so much for having me. And you're right. Once you have these great legal documents in your hand, what's the next step? What do you do with them? And so what my goal here today is to help equip you with a conversation that you need to have with your financial institution. Again, my specialty is in deposit management. I'm specifically with Capital One Bank. And so daily conversations for me are around how my clients' accounts are structured, making sure that they align with their goals, not only now financially, but in the future, and are well aligned with their estate plan, whether they have one with an attorney or they don't. So I do have a PowerPoint, again, very informal, but it's sometimes easier to read than it is to just sit and listen. So hold on one second for me, and I'm going to share my.
While you're pulling that up, I just wanted to clarify something, because I did share that you are, a relationship manager in private banking, but I am guessing that this is information for all of us, no matter
Absolutely.
what our assets may be. Okay.
Absolutely. This pertains to everyone. I mean, everyone at various stages in your financial life should sit down with a banker, whether it's at your local branch or if you have a private banker, just to say, what do my accounts look like? Are they working for me? Are they still structured in a way that makes sense for where I am currently in my financial life, right? Okay, so here we go. All right, so today I'm hoping to do a couple things. Review account titling as part of your estate plan. I'll talk about various different types of account titling that you have access to with your financial institution. What's the role of a beneficiary? Is it appropriate for you to be designating them on your accounts? How various titles and beneficiary designations impact probate, which would occur after you pass away. And then I've got two frequently asked questions that I'd like to walk through, which are really good case studies of, very specific general questions that I get from a lot of my clients. All right.
Oh, terrific.
Let's jump. Okay. So why is account titling important? So it ensures that your assets pass to your heirs in a way that you intend for them to be passed, right? So it makes sure that it's a vehicle to make sure that your estate plan is enacted the way you intended, right? So you may have a conversation with your attorney and say, I want this percentage of my assets to go here. I want my husband or wife to be a joint account owner, and I want him or her to have full access to the accounts when I pass away. Account titling is one of the vehicles that are going to allow you to make sure that the financial institution is going to support you in those wishes, that can execute them appropriately. So what we find is many people mistitle their accounts and sometimes designate beneficiaries that actually conflict with the estate plan that you may have planned out with your attorney, right? And the two reasons I see that most are because there's a concern around FDIC insurance. And you also have to consider what the legal obligation of the financial institution you're dealing with is in terms of your account title. So let's just say you have an account in your name and you have one beneficiary on that account. The bank has a legal obligation to fulfill the account wishes as they are titled, not by your will. And so a lot of people don't realize that by making decisions at your financial institution may have a negative impact or a different impact than your estate plan necessarily provides. Okay.
Will you give us an example of how that might happen?
Yeah, sure. It's on one of my later slides.
Okay, good.
I'm out here and then I'm gonna come down.
Great.
That's the goal anyway.
Because I was trying to envision that in my mind, like how that
I know.
Happen.
Well, and it's a very scary thing for me to have to tell a client, you've told me you have a trust, however, your account is not in trust, and you actually are leaving this entire account to child A when they have child A, B, and C. So this is why this conversation is important, right? Okay, so a couple of standard account titling options that are available at most financial institutions. However, these options can vary depending on the institution you work with. So you have an account owned by a single individual. That's very common. Or a individual account that has a beneficiary designated. Okay, so those are sort of your two individual type of accounts. Then you would have a joint account. Most of the time I see that with married couples. Sometimes it's a father and a parent and a child, right? And sometimes that's done to sort of necessitate bill paying in later stages of life. Then there are joint, so these joint accounts either have right of survivorship or they don't have right of survivorship. Right of survivorship means that the account can continue to be used by the account owner without a probate consequence. And again, we'll go into that a little bit more in detail in a moment. And so after your joint accounts, then you could have a formal trust that you've created with your estate planning attorney. I'm going to keep moving. I know there's going to be questions, but I promise I'm going to answer them.
Terrific.
Okay. Beneficiaries. A payable on death designation is one probate avoidance technique that can be used. Oftentimes I see this for clients that may not have the need for a large estate plan, right? You might not have a need for a living trust. You might not have, assets that are required, to have a more complex estate plan. When you have a beneficiary designation, a payable on death designation, the bank will collect the record for that beneficiary. Typically, I know Capital One, we collect name, social security number, and date of birth. And the reason why we do that is so that we make sure that we're giving the money to the right person at the end of the day when the time comes, right? We'll collect identifying information for the beneficiary and then cut them a check directly. That point is important here later. Upon the death of the account owner, the funds in the account belong to the named beneficiary. And in the case of multiple beneficiaries, the funds in the account are most often divided in equal amounts to those beneficiaries. So say you have a parent and you have 3 children, right? You have 3 children and you have only designated 2 of them as beneficiaries because we have forgotten to go back and add the 3rd one for various reasons, right? If something were to happen to you, that money is split between your 2 beneficiaries, not all 3 of your children, which your will may specify. Okay, so that's a glimpse into the type of potential account challenge that you would your beneficiaries would come
Lindsay,
to.
whenever you open an account, a bank account, does the bank automatically ask for beneficiaries? It's been so long since I've opened one, I can't even remember if.
I would say you wouldn't want to assume that they will, right?
Okay.
Banks, obviously there's, a lot of liability issues with giving advice, right? And so, all of these conversations that I'm having are in very generic terms. But when you are coming to the bank, you really should be driving that conversation. Yeah. And that is something that I think most people don't realize, that they really are the ones who are dictating the account types that they're getting. They might not always receive, quote, advice on which type of account to open.
Very interesting. Good. Okay.
All right. So, all right. Now here's where we might get into a little bit of nitty gritty. And I'm going to hold you guys accountable. Yep. You have a question?
No, go ahead.
Okay, perfect. All right. So I'm going to hold you guys accountable for stopping me or slowing me down if we have specific questions. All right. So I told you that I would walk through the different account titlings, but then what happens in a probate environment, right? So individual owner account, meaning that you have an account, you are the only owner of the account, and there are no beneficiaries designated. Those funds will go through probate. The bank will have to cut a check once the executor, gives us the proper documentation to the estate of the deceased, right? So this is your most sort of generic, everything's going to go through probate type of account, right? An individual account with a payable on death designation. So again, account in a sole party's name, but they may have 1 or more beneficiaries designated. At that point, the bank's legal obligation is to follow the wishes of the account owner when they enrolled in this account and selected their beneficiaries, right? So usually once an account owner passes away, that account will be handled by the estate team, where they will be evaluating the beneficiaries on file. And then most often they would be cutting a check directly to that beneficiary or beneficiaries in equal parts, right? I'm just going to pause there. Pretty good. All right. Now, joint owner accounts. So most typical joint owner accounts going to be usually husband and wife, right? Or partner, two partners. So joint accounts without rights of survivorship. These are becoming a little bit less common. Capital One does not actually offer this type of account, but this is where if one owner passes away, the surviving owner still has access to the account, but it could still be subject to probate. And so this is one of those conversations that you really would only know that this is the type of account you're in once you have a conversation with a financial institution. Most jointly held accounts fall into the next category, right? Jointly held accounts with rights of survivorship. So this is when, again, a jointly held account between two or more people, let's keep it simple and call it two people. One of the owners passes away, all of the funds are accessible and also go to the surviving owner right away, meaning there's really no interruption from the way the account behaves, and there's no probate issue that is involved in this type of an account. And then once that second owner passes away, if there have been no further changes or updates to beneficiary or titling, then it will go into a traditional probate title, right? And so sometimes what you see is you'll have a joint account that's been open for 20 plus years, 25 plus years. One of the partners in the relationship will pass away, and then there's no second look at the account titling and what will happen to that account once the second individual passes away. And sometimes that just creates one extra hurdle for a loved one. Okay, jointly held accounts that have right of survivorship, but then also have beneficiaries designated. This one is one of the cleaner types to have as far as survivorship and access to funds, as well as avoiding probate potentially. Is you have a jointly held account, one of the owners passes away, and that owner can continue to use that account through her life if she decides to keep the titling and the account number the same. But then upon his or her death, the funds will go to the estate team within the financial institution and usually are paid out directly to the beneficiaries listed on the account. Okay. Finally, we have trusts. So trusts are in their own sort of separate little bucket. They are usually drafted, obviously drafted by an attorney. If you do have a trust document, the assets are managed by a trustee, right? And the reason that trusts tend to be used a lot in estate planning is that it allows the successor trustee to immediately come and start taking care of the account right away. They could be paying out to beneficiaries that are already listed in the trust. So it really, it has some tax advantages, or could have tax advantages for you, but it really creates a seamless experience for either the executor or successor trustee that you've chosen to maintain that trust after you pass away. So that was a lot of information, so I'm going to pause for a second. Are there any questions out there?
Well, let me ask this question. Yeah. With the jointly owned account with right of survivorship, which I'm going to guess is pretty common. Pretty common, yes. Husband and wife have a joint account. One of the spouse, let's just say the gentleman dies, the husband dies. Couldn't the wife then just take that account and change it, roll it into her personal account if she has one, yes, or do anything she wants with it?
Before or after death is important to note. This will come up later, but okay, yes, jointly owned funds, may be accessed at any time during the life of the account. So, okay, after a spouse passes away, or a joint owner passes away, you usually would contact your bank, right? You usually are settling things, but Most often banks will can remove the deceased owner, and that way that account will continue to live on and be used just fine. But also, if no action is taken, then it will continue to move forward without much issue.
Right. But then when the surviving owner does die, it has to go to probate because no one else was set up. Gotcha. I like what you said about pausing to see if there are any questions on this information in particular. And I'll give you, let's take a second and let anyone go ahead and type in. I know that we talked a lot about having, and I'm sure you're going to get to this, having a power of attorney, for medical, or for financial. So what if how does that play into?
I'm so glad you brought this up, because honestly, I did not have that in here, and it's huge. It's a huge consideration. So I'm glad you brought that up.
I'm always thinking, Lindsay. I'm always thinking.
No, it's great, and it's funny because I knew there was something I was leaving out, and that's it. So, all right, power of attorney. So a power of attorney is a great tool to have. However, power of attorneys can be written in many, many different ways. Some include a financial aspect, some do not. So it's important to, and then some require, if you have more than one power of attorney listed in your power of attorney document, sometimes those people have to act together, which can be a challenge. But one of the most important, two very important things regarding a power of attorney, when you have one, the important thing is, if you think you're going to have to execute that power of attorney, is to make sure the bank has it on file ahead of time. And the reason why is because, in our extremely litigious society, our banks are going to do their due diligence before they hand over signing authority to a power of attorney, right? We're going to have the document on file. Really, ideally, each bank would want to have their own power of attorney also on file, which is signed by not only the account owner, but the attorney in fact. And oftentimes when a power of attorney is provided after an account owner needs that assistance, there could be a delay in adding that power of attorney on while the bank does its due diligence. So just very important to try to stay ahead of that. Yeah. The second thing to keep in mind is that a power of attorney ceases to be able to be used upon the account owner's death. So sometimes I'll see an individual come into me and say, well, I need to make a withdrawal from my father's account. He passed away last week and we need to pay for funeral expenses, whatever the case may be. And unfortunately, I won't be able to conduct that transaction because the power of attorney is a document that only is able to be acted upon when the account owner is living.
That was something that you had mentioned to me in one of our conversations, and I thought that was really eye-opening. So basically, your power of attorney ceases to exist when the account holder ceases to exist.
Well, and you have to realize, in time of COVID is very unusual anyway. However, I'm experiencing right now a challenge with an account. Had a power of attorney. However, once the gentleman passed away, the account now has to go through probate because there was no beneficiary designation on the account. Probate can't be finished, or a check cannot be written to the estate until all of the documentations required for us to cut that check, which included letters of testamentary, letters of administration, depending on the state, and a death certificate are provided, right? And a letter of instruction given to us by the executor. Right now, the issuance of death certificates is behind, and we're talking about a 6-week lag in being able to give this family the funds that they need to, they were looking for to pay for the funeral of their loved one. And it's a very difficult position to be in because there's no foul play involved. However, the rules exist to prevent, fraud, and they apply to all of us regardless of intent. So in that situation, even though they had a power of attorney, they didn't have the beneficiary equation in the equation, or they didn't, have a joint owner where the funds could be immediately accessed. And so that account is sort of stuck until we have all of the documentation that we need to cut a check to the state.
So what if your mother is aging, she adds you to her checking account as a signer?
Mm-hmm.
Will you still have that ability upon her death, or
Yes.
is it the same scenario?
Yes.
You will.
Let's see here. All right. Thank you for that.
And actually, we do have a couple.
Transition.
we do.
Yeah, I can pause. Let's pause on your question, and I'll go back. We're going to pause on your question because that's that's one of my frequently asked questions.
Oh, okay, great. So Phoebe Graham asked, so what is the best document that a family member should have to be able to access the account of the deceased to handle their affairs?
Well, and again, that's going to vary widely. So let's say for ease of conversation, it's an individual account, right? Let's call it mom's account. If mom's account does not have any beneficiaries on that account, you would need to provide as an executor, if you're listed as the executor in mom's will, letters of administration, right? That's for the state of Maryland. Death certificate, and most banks will ask for a letter of instruction, which simply means, please close out account number 1234, and issue a check to the estate of mom, right? That process takes several weeks, right? So for most banks. So I would say, ideally, if you're going to go through probate and that's what mom and dad want, right? Just expect that access to that money is not going to be immediate. So if we really want to have immediate access to mom's account once she passes, then we either need to have a trust in place where a child or the named individual is listed as a successor trustee, so that change can happen fairly quickly. And that way you'd have immediate access to the account to pay as needed, or added as a joint signer, whereas the rights of survivorship will allow the continuation of the account. And that way you can continue accessing the account. Or finally, if mom's wants to maintain control of her account through her life, listing children or child as a beneficiary would allow us to cut the check directly to the beneficiary. And again, there is going to be a little bit of a lag time there because we do have to collect the death certificate and the appropriate information on the beneficiary before that check is written. Okay. And again, all of these policies depend by bank. I can speak for Capital One that most estate operations activities, meaning the accounts are being managed by our estate team after an account holder's death, do take, I would say anywhere between 5 and 10 business days if we have all of the documentation.
Wow. Okay. And just one other question before we move on. 2 siblings are beneficiaries. One dies with no spouse or children before the parent dies. Then the parent dies without changing will. Does living sibling inherit all the money?
So again, if there's a beneficiary listed on the account, the bank has to go by the beneficiaries listed, right? So if a beneficiary is deceased, that will be uncovered during our estate team process. And then yes, the check will go to the surviving beneficiary. And again, each one of these policies, you will need to talk to directly to your financial institution. But yes, it does not go to spouse or children of the deceased beneficiary. There would be no way for us to determine that.
Okay, all right, let's move on. We do have some more questions, but I want to give you a chance to go through all of your presentation before we get to additional questions.
I'm about wrapped. So these are two questions that probably are in people's mind anyway. So why not name my child as a joint owner to all of my accounts? Is there a better alternative? So this answer is going to be different for every single family. And the reason why is because parent-child relationships are there's a huge spectrum, as you would imagine. And oftentimes there's more than one child, right? So there's usually a child that has sort of been designated as the parent helper sometimes, right? The one that's going to help manage the bank accounts. And again, as we discussed, once you add a joint owner to an account, they have full access to an account, right? So there's a couple of issues there. One, do we really want one child to have access to all of the family's, funds, right? Yes, we all trust our children, but things happen, right? So you have to, as you're doing those processes and adding children, you just need to make sure you understand the access level that comes with adding as a joint owner. So oftentimes, as I talk to parents who are wanting to add a child for the sake of an additional set of eyes, somebody that's going to take over some bill paying, right? We usually set up one account for them to be an owner on, and then either address the rest through their trust, address the rest through beneficiaries. There's a multitude of ways that you can not only protect your asset, but also hopefully avoid some of that family struggle that may come after you pass away. So I usually believe that the best choice is not to add one child to all accounts or add multiple children to all accounts, because usually the more hands in the pot, the more challenging it is to make sure everyone has line of sight to what's going on.
So what's the better option?
Like, again, it's individually, you should really individually customize it based on your family structure and comfort level. I have such a wide variety of examples. Oftentimes though, we've always thought about what happens after the mom or dad passes away. What happens to that money? Who has access to what? And what is your estate plan, so we can make sure that all of your wishes are followed after your passing? And how do our current account structure support or actually, may limit that in a degree? So sometimes we find, oh gosh, that's not really what I intended to do. Right.
All right. So this kind of goes along with what we were just talking about, this chat question. So basically, all accounts should have beneficiaries, plus wording and trust to ensure accounts are part of the trust. Any example of what the literature sounds like?
So it sounds like people are asking, should there always be beneficiaries on accounts?
Yeah.
My answer to that is no, there shouldn't always be beneficiaries on accounts. Because oftentimes, if you have beneficiaries but also have a trust, they fight, right? They actually are not aligned. So, if you have a trust that's been established as part of your estate plan, oftentimes beneficiary designations can conflict with that legal document. So we would really want to make sure that they are in agreement, so that we're sure the allocations of assets that you've specified in your legal document align with what's happening in your bank accounts, right? If you don't have a trust, then maybe beneficiaries are the right option for you, but you would want to be sure that as you're adding beneficiaries, you're comfortable with who is left with what piece of the pie, right? And the reason I say it that way is because in my next question here that I get a lot is how does my account titling impact my insurance coverage, FDIC, for most of our financial institutions. Sometimes I have clients, I shouldn't say sometimes, frequently I have clients that are concerned about the amount of coverage they have with FDIC, which is its own very complicated conversation, but they end up adding these beneficiaries that to increase their coverage, but yet are in complete conflict with what they would want to happen to their funds if they were to pass away. I'll give you an example. Grandma and grandpa add 5 of their 6 grandchildren as beneficiaries to their various accounts. Upon their death, if it hasn't been reviewed, 5 grandchildren are getting checks and the 6th one does not, right? And so my point being is that beneficiaries can be a great tool, but if they aren't reviewed on a fairly, I would say, life event changed basis, you could end up with an estate plan that is messier than you intended and in conflict with either your will or your trust.
Got it. That the whole FDIC
whole nother bag of words.
Of it is that really complicates things a little.
It does. It does. And I personally, an FDIC conversation is best done one-on-one. The reason I've added this link here is this is my, jot it down. This is my go-to resource on FDIC. It's a calculator that's you don't have to put any personal information in. You're just putting in your titling and the amount that's in the account, and it'll show you your coverage. It'll allow you to manipulate it so you can increase it or decrease it, depending on the titling. It's a really great resource. Highly recommend it.
Wow. Okay. See, I never even thought about that. Oh, so much to think about. All right. So any other questions? Let's see. We already addressed that one. Go ahead and put your questions in the chat box. We do have some time. So anything else, Lindsay, that you want to add while people are typing in their questions?
I think, I can't encourage enough, just taking the time to meet with a banker at your financial institution. They are going to know how their estate office works, how they process accounts after the death of an owner. They are going to be able to review your beneficiary designations that you forgot you put on there 10 years ago. They'll be able to update them. They'll be able to look at your titling, who has access to what, and explain to you how that works. Online banking right now is a huge topic. I have aging parents who have children that are wanting to help with their finances and they aren't online, right? But yet the son or daughter may want to be online, right? To help manage the account. So again, that's a great banker conversation. What's the risk there? What account should son or daughter have access to best help you? Is it a problem for that one account to be online and accessed online? That's a bigger conversation than you might think it would be, but it's an important one to have.
Wow.
I'd like to step in here, Lindsay. Thank you so much. This is great information. And my takeaway is we can't just assume that what our wishes in our will be automatically respected by the financial institution. So we frequently have to review and make sure that what we intend happen in our will is also what's going to happen with the financial institution. So this is great information, and thank you so much for sharing that. That was my biggest takeaway.
Well, and you would think beneficiaries are super common, and in some communities they are, and some they are not. In the community I commonly serve, which tends to be a higher net worth community, I see beneficiaries all the time, but they're often applied incorrectly. But in my branch manager days, I've serviced other communities where they don't use them at all, and it could be a really useful tool to avoid probate. So again, it really just depends on your unique financial situation as to, what that looks like for you.
Thank you.
Terrific. All right. I do not see any additional questions. It looks like you, definitely not we, you really hit the nail on the head.
Yeah. Well, I know.
Perfect. I was just about to ask that. How can our friend find you, Mrs. Michaud?
My phone number, my email are there. I'm absolutely happy to have a general conversation with anyone. I will be limited in the financial institution specific advice I can give if you're coming to me with a Bank of America account, but I can talk in general, in generalities, and point you at least in the right direction, or give you some questions that you can answer ask your financial team at your local branch. That should help you lead the conversation if you'd like. But again, happy to help in any way I can.
Thank you so very much. And in answer to the question that just came out, yes, there is a recording of part 1, and it was in the marketing literature, but we can certainly send that out to you. We will put we'll put a link in with the recording of this part 2 so that you have both at your fingertips. Lindsay, this was amazing, as I knew it would be. Please reach out to Lindsay. She truly is so helpful. She's there to help. And of course, reach out to us should you need us in the future for yourself or a loved one. All right. Thank you so very much. We will be back in 2 weeks with, I believe we're going to be talking about making your home safer. Little things that you can do inside your home to make it safe for you and your loved ones. All righty. Thank you, Lindsay. Take care.
Thank you.
Bye, everyone.
Thank you, Lindsay. Thank you.